The Judicial Conduct Tribunal will resume hearings this week in a incapacity complaint lodged by Free State Judge President Cagney Musi against Judge Lepona Lekale. The complaint alleges that Judge Lekale has been unable to perform his judicial duties for the past 6 years due to ongoing ill health. The tribunal will determine whether there are sufficient grounds for a finding of judicial incapacity under the Constitution. For more on the legal implications, we're joined by Neelan Karikan, who's the president of the Judicial Officers Alliance of South Africa. Neelan, good afternoon. Thank you so much for joining us. Really do appreciate it. Before we speak on the merits and the detail of this matter, what is judicial incapacity?
Well, judicial incapacity entails the inability to perform one's function as a judicial officer, whether it's presiding, whether it's dealing with inquiries, or any form of judicial work, that inability to work, in fact.
Yeah, one would imagine that there is a clear outline that if you are not healthy and fit enough to perform your duties, that automatically you would be relieved from your duties, but that doesn't seem to be the case. This needs to go through the Conduct Tribunal, which makes it seem like an adversarial process, and I would assume that it's not, in this instance, not necessarily adversarial in nature. Talk to us about this matter.
Yes, it's definitely not adversarial. It's rather inquisitorial. It's an inquiry. And ordinarily, the whole intention with these types of processes is to try to accommodate the person that is affected. Will this person be able to perform their work without fear, favor, or prejudice? Do they have the necessary ability and capacity to actually perform the tasks for which they have been assigned? And in the normal course, you will understand that beyond judicial work and being a judicial officer, in the normal working environment, it quite often happens that employees or workers are unable to perform their work, either through some type of irregularity, but quite often it is because of ill health. And if it is because of ill health or some type of disability, then quite often the employer would be required to accommodate that employee. And in this particular case, it is a judicial officer who is performing a specialized, specific task. And the question is, are there other duties that the judicial officer can still perform whilst still retaining that capacity as judicial officer? And if that answer is more or less correct, you can maybe do certain other types of work, because it's not unusual for employees or judicial officers to have some type of disability. And if they have a disability, they are accommodated, whether through technology, whether through facilities, their workspace, getting some form of assistance, we're getting a driver if they have an inability to drive, or whatever the case is, they generally are accommodated first. Those aspects are fully exhausted. And in the event that there is nothing further that can be done, then potentially incapacity generally kicks in, and it's important that there is this facility through the Judicial Service Commission to engage on that on an inquisitorial and fair level for all parties involved.
What level of detail does the Conduct Tribunal have pertaining to the health condition of Judge Lekale?
Okay, the health, obviously this is a very sensitive matter because we're dealing with health issues, and these are generally and in the ordinary course private matters. But when it comes to the inquiry itself, the commission or the body that will actually be dealing with this inquisitorial inquiry, they are entitled to all forms of information when it comes to the medical condition. It's not necessarily open to the public at large, because of issues of transparency, dignity, and so forth. But that doesn't mean that the chair or the person in charge of the commission does not have the ability to allow the public at large to be party to these proceedings, whether it's the media and related institutions. They are entitled to be there, but then they would need to show that it's in the interest or it's in the public interest, and there is a need for transparency. If that threshold can be crossed when balancing the interest of the affected person whose dignity is involved, then potentially it can be allowed in the public space insofar as the media is concerned. But the commission itself, or the committee that is dealing with this aspect, is entitled to all and full information. Obviously, there's aspects of confidentiality, and there are some limitations which the aggrieved party may have that will say, no, you're not entitled to this, you're not entitled to that. But there becomes an entitlement, so to speak, when it deals directly with the ability to perform your work. Now, if you are unable to perform your work, and in this case, your judicial functions in all spaces and in all views, then if you don't have that ability, then you need to justify why you would still be entitled to retain that position. Because remember, judges are ordinarily judges for life, and they get their ordinary remuneration, their benefits.
So that was actually going to be my next question.
Yes.
It seems to me that there's a willingness on part of Judge Lekale to still continue his judicial duties, despite the fact that, you know, there's a lifetime benefit to being a judge. That is, if he retires, he would not be prejudiced in any material way from remuneration and or otherwise. The fact that he hasn't, as a result of his health, means that there's still a willingness on his part to perform some form of duty?
Remember, when it comes to High Court judges, there are certain regulations and rules that govern them for them to actually reach the benefits that they're entitled to. My understanding is there needs to be at least 10 years of continuous service and so forth. I'm unsure as to what the status is of the colleague in this particular matter, but there are certain rules that are in place. If he is entitled to almost like being medically boarded, so to speak, there may be certain benefits that he would be entitled to, but there are certain pro formas or regulations or formulas that need to be adhered to. So if the person is entitled to leave on own accord, then there's certain procedures that need to be followed. I cannot see why it cannot happen, especially because we are speaking of incapacity. And as the employer and when the complainant has lodged the complaint, I'm sure these discussions must have happened. And there would have been some type of mediation in the normal course. It doesn't ordinarily come to a stage like this where we need to have this engagement almost like in a conflictual nature when it can be resolved internally. Because these matters, you must understand, these matters are generally very, it's not usual. It's very isolated.
In fact, I actually wanted to touch on that, Neelan, just to step away from this particular matter for a second.
Yes.
Judges generally are in their later years of life, senior, where ill health becomes a lot more prone. How prevalent is ill health impacting the bench by and large across the judiciary?
You must understand, because of the nature of the work, there's a lot of aspects of ill health because of age, particularly among senior judicial officers like High Court judges, and even amongst the magistrates. Remember, we've got magistrates with at least 30, 40 years of experience. So a lot of them are quite senior. When it comes to their health, you must also understand that judicial officers currently, even High Court judges, a lot of them currently are being appointed at fairly young ages. It's not like previously. Previously, our judges used to primarily come from senior counsel. But right now, they're coming from senior magistrates, regional court magistrates, attorneys, advocates, and a lot of them are fairly young. But remember, they are quite competent. We've got competent judges like our current judge president, Carol Sir. She was there for a long time. She started off very young. We have Judge Colleen Collis, very young. So you must understand, they are not at an age where they're going to be retiring anytime soon. So the older people, yes, there are a lot of them.
To the point, how prevalent is ill health across the sector? It's also, and I also have to point out, it's an incredibly demanding job. Judges work long hours for long periods of time under immense pressure to deliver judgments at great quality on time, and you know these pressures can pile up and can affect a person. Just in terms of just health in general, how prevalent is ill health across the sector, and what impact does that have on the judiciary?
It's fairly widespread. Remember, on a physiological level, in terms of your heart, lungs, and the like, the general health. Remember, in terms of our norms and standards, judicial officers need to preside and literally sit for 4.5 hours per day. And beyond sitting on the bench in a certain position, right, you must know they don't have ergonomic chairs and so forth. They got to sit there. And you must know they are sitting there for years, decades, 10 years, 20 years. They are literally having back problems, spine problems, and the like. So the prevalence of ill health is systemic. It's very systemic, but most importantly, as you pointed out, the type of work that they do beyond criminal work, civil work, motion court trials, and complicated matters. Beyond all of that, there is that mental strain that they experience.
Yeah.
And they don't have that natural benefit of having a wellness program that just rolled out. There's no debriefing. And remember, we've already complained previously that within the judiciary, there isn't these aspects of security, and magistrates and judges are being, threatened, killed. They're being intimidated all the time. And there's issues of remuneration and whatnot. And as JASA, the Judicial Alliance, we are at the forefront currently, inclusive of dealing with the Independent Remuneration Commission, because they need to assist us and come to the party. Just as with this is one isolated matter. One isolated matter, because when it comes to misconduct in the High Court, and now we're talking about incapacity, remember the Magistrates Commission also deals with these aspects when it comes to lower court judges, dealing with 95% of all judicial work. So this is just the tip of the iceberg, but we need to deal with it very sensitively and balance the interests of the judicial officer together with the commission.
Neelan, we're going to have to leave it there. Thank you so much for your time with us. Really do appreciate it. Neelan Karikan is the president of the Judicial Officers Alliance of South Africa, talking to us on that.